Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you're enjoying our legal education content. And with us tonight is a new guest for the channel, someone we've been trying to get on for a while. We're finally able to secure him, a new lawyer to add to our Rat Pack mix. It's Richard Hogue of Hogue Law, here to tell us about all the computer game and virtual reality things that there are. So let me introduce my guests. Mr. Hogue himself. How are you doing, sir?
I'm doing okay. Thank you for having me. Yeah, absolutely. It's very nice of you to say, trying to get me on for a while. I don't know if I've had a channel for long enough, but certainly I apologize for not being able to get on here earlier.
No, you're cool with me. I like your stuff. Why don't you introduce yourself just to start? Tell us about, what you like to talk about on your channel.
Oh, sure.
Subjects you like to cover. Give us a little background about yourself.
Sure. So, I think interestingly in this space and in kind of media spaces in general, I'm not a litigator. I think a lot of lawyers are litigators, appellate attorneys, those kind of things that talk about these issues, even an intellectual property lawyer. And so I focus on transactions. I grew up doing mergers and acquisitions, venture capital, financing, private equity, hedge funds, all the really evil people you see on HBO shows and whatnot. And so that's what I grew up doing until about 2008 when I had to branch out as venture capital dried up a little bit in Michigan and started doing a lot more software as a service, because frankly, the firms around where I was didn't really have a strong version of that. And because I've loved technology for as long as I've been alive, including, but not limited to, in lawyerese, video games. So when I started my own firm in 2016, one of the things I wanted to do was do some marketing, get out there with more of a personality, and not just be big firm light. And so shortly thereafter, I started a YouTube channel where I was talking about, as a test case, The Last Jedi, which turned out to be a fairly popular YouTube subject. And then ultimately a show that I started called Virtual Legality, where the elevator pitch goes, we talk about the business and law of video games, music, movies, and television, the pop culture you're already reading about, but that maybe the articles and journalists are getting just at least a slightly bit wrong. Because they're not doing mergers and acquisitions every day. And so when they talk about Microsoft buying Bethesda, they could use a little help. So we do that in that space, and that winds up with a lot more breadth than I would have anticipated when I started it. We do talk about video game contracts, a lot of terms and conditions, a lot of software licenses, what those mean, how Electronic Arts operates, how Activision operates. When Microsoft buys another company, they might buy another company by the end of this video. We don't know. They just buy things all over the place. And have good conversations there. We also wind up talking about the occasional Supreme Court decision, major topics that I find interesting, like when the Trump campaign wound up suing my state. I'm from Michigan, so that was the first filing made, and so we talked about that. We talked about what that means, and so it's a bit of a panoply of subjects focused on that pop culture. But also with some lighter elements and some more political elements. Occasionally get an extra video from me where I editorialize a bit, but it's not as often as some channels.
That's really, really cool.
Thank you.
Yeah, it's just interesting to see how different things, how we do different things. My background is intellectual property, particularly on patent side, and I basically do everything except that on my channel because I'm tired of talking about it. So it's I'll cover anything else just because it's interesting to learn about a whole bunch of stuff, and it's always educational to me because I learned something.
Well, that's the fun, right? I don't know if everybody knows this that watches our stuff, but the fun that I have is, how am I going to talk about this? How am I going to make it a YouTube video? And having that process is part of what's fun about life, is learning new stuff every day.
Yeah. It's really great stuff. And you have a lot of content on your stuff. You put out a lot of videos. It's even more than me, I think.
I don't know. It's a lot of fun for me. It's back when I started doing law, when I was a very young associate, one of the things I like to do to kind of get up to speed for my day was to go and read articles and things that I was interested in. And I called that the pre-work sit. And part of the channel was essentially saying, okay, well, when I find something I really like, let's see if we can do a video about it and maybe have some fun talking about it. And selfishly, I like getting those comment sections and having those discussions with people about subjects that I find interesting. And that's a lot of fun.
They love you, Richard. They love you. I see your
comments. Right now
section.
They do.
You got a nice
get bigger,
little
more
base.
People hate.
You got a nice little base. They love you. They love your stuff. They love your dulcet tones. You may have the best voice in the game.
Well, I've only now got a camera set up. So we went 2.5 years without anybody seeing my face. I still get a lot of, that doesn't look like Rick. It's I think I've always looked this way, but it is what it is.
Well, that's not the first time that's happened. There's another famous story about a guy named Rick Ashley who didn't look like people might have expected. So, he might be in good company on that one.
There you go.
So I thought maybe we could discuss some things that might be of mutual interest that were in the news. So I have a couple stories that I've queued up, and we can just talk about anything else too. It doesn't have to be like super formal or anything. It's like, whatever sounds interesting at any given time sounds fine.
Sure.
But I thought we could discuss about two things that are sort of in relation.
Okay.
In relation to social media, which relates to Communications Decency Act 230, at least peripherally. It relates to the ability of social media providers to choose their own content and who they do and do not host. And some of the states are striking back.
Okay.
There's some obvious First Amendment issues that pop up both ways. But we got two that are kind of going through the pipeline right now. So one is in Florida, which just passed the Senate in Florida, which would prevent a social media provider, think Twitter or anyone else, from deplatforming a political contestant, someone who's
somebody in an
office.
election.
Yeah, someone who's running for office. So the idea is that someone who's in office or running for office would not be able to be deplatformed, because I suppose the theory is, the people have a paramount interest in being able to get to political speech in particular.
Yeah,
which seems pretty, solid on First Amendment grounds. If you're doing your hierarchy of First Amendment speech, political speech is usually at the top of the pyramid. And so, people have a paramount interest, and social media providers shouldn't be able to prevent people from hearing the voices of, for example, Laura Loomer, who got kicked off Twitter, or Trump, or people of that ilk. So that is Florida's proposal, and then Texas is going one step further.
Okay,
which would prevent people, which essentially prevents social media from banning anybody based on their viewpoints. So this is a more global viewpoint discrimination idea. So the idea is, you can regulate content, but you can't regulate viewpoints. So you have to let Republicans and Democrats and libertarians and the socialists all speak, and you can't discriminate against them for what they say. Now, this is at least somewhat also been reflected, and I don't have the webpage up for it right now, but this has been somewhat reflected in the Department of Justice's proposal under Trump. So at the very, very end of his administration, the Department of Justice came out with a proposal for the reform of 230. Yeah. And their idea in so many words was social media providers could have any policy they like, but they had to be very clear about their policies. Mm-hmm. They couldn't make statements inconsistent with their policies. They actually had to apply their policies consistently. And, they couldn't be deceived, which I thought had much better prospects, because it's essentially a truth in advertising provision. The way
Right.
So, but the more global idea is that there's a whole bunch of proposals around this. So my question is to you, I guess, what do you think about these proposals, either individually, collectively, what they're trying to say, their legal validity, all that good stuff?
Sure. Well, I did a couple of videos on those. The Trump, there was a draft, and then it was finalized the same day, which I thought was a really interesting process to watch the staff kind of move things around. But I do remember those orders going out. I would say, I'm a corporate lawyer, right? So some people come into my space and say, I represent the evil guys, and I have a tendency to look at things. I like to think more neutrally than some, but you could argue different perspectives. The thing I worry about, and I've got plenty of videos that talk about YouTube censorship and Facebook censorship and Twitch and terms of service and things like that, is the forced speech aspect, right? That Twitter is still, at bare minimum, a private service. Maybe it shouldn't be. You get some kind of statements from Justice Thomas and things about whether it should be a common carrier and whatnot. Right now it is. And the First Amendment still prohibits forced speech. And so if you look at something that is absolutely abhorrent to Twitter, now it's a company and people have feelings, not companies, but is abhorrent to the people that run Twitter, should they be forced to have that on their platform? It is an interesting question that I think gets lost in the should they be allowed to block people? And I come out mostly believing in battle of ideas, and I'm a pretty free speech absolutist, and I want people to be able to go out there with their stupid thoughts and have them combated by better thoughts. But at the same time, it's easy enough to tell Twitter that they shouldn't be allowed to do something. It's that up and comer And that might not be Parler. It might be somebody else that is in a basement figuring out a way to compete with it. And I do, as a student of history and looking at economics and law, worry about regulatory capture. You start putting these rules in place, and they're going to have more negative ramifications for the small up-and-comer that's trying to get that market share than they are for the big established companies. So, it's a very complicated issue, and I don't want to sit here and tell you that I've got the solution, because I think there's a lot of good points on realistically both sides. I don't love folks getting quote unquote canceled, run out by outrage mobs of either ilk, but I do worry about legislative solutions to what should be a fairly free economic enterprise. So, I wish I had a better answer for you. I think Texas, by your description, goes too far. I don't know how you quantify what they described there.
Maybe it's better in the bill.
Yeah, maybe it is. Maybe it is. We'll give them credit. I don't like to give legislative aides that are writing these things credit. When I read them, and it's often worse.
Yeah.
Yeah, maybe it's better in the bill. As described in that article, it's like, oh my God, viewpoint discrimination. Well, all right. Are you trying to impose a fairness doctrine? What does this all look like? Long scope. The elected officials and elections is a little bit easier. That's going to be a limited class of people. And you say, okay, this is a limited exposure risk. You find it abhorrent. It's for a short period of time. It's people that were elected by the citizenry of whatever jurisdiction. And so I think that's at least a metric. It's a bright line where you say, yeah, you can't do this thing. And so I worry about it a little less than you can't do something about viewpoints. And that's coming from somebody that looks at 230 and says, my God, how could you write otherwise objectionable in there? This law means nothing once that language is included. So
didn't see that one coming, Didn't foresee that one coming. Yeah. When they wrote it, they definitely didn't have that in mind. I think people forget sometimes, even people talk about 230. 230 was one small part of an overall bill. It was called the Communications Decency Act. It
was the children's pornography bill. Yeah,
it had many other sections, and now 230 is the only thing that's left standing.
Well, the hilarious part about 230 is that the recitals, which are not always in bills, start out by essentially talking about how wonderful it is that all political people can talk about whatever they want. Sure, 230. And then you get into 2021 and, hey, what Twitter finds otherwise objectionable might not be what you or I find otherwise objectionable.
Yeah, so maybe the solution isn't right on the free speech angle as such. Maybe it's more in the antitrust angle where things need to be reformed. Because I don't think the problem. First of all, I think the DOJ's proposal solves the problem without free
the truth in advertising stuff.
Yeah, truth in advertising.
Okay.
It's like, you can have any policy you want. You just have to be truthful about it. You have to be clear about it. You can't make statements inconsistent with it. You actually have to follow it and apply it consistently. After all, it's your policy.
Yeah, something like due process.
Yeah, just being truthful in what you say. So I'm like, that makes sense because that's just a commercial speech regulation. It seems like intermediate scrutiny without, getting too much into, forcing you to host particular ideas where you're worried about, stuff like that. Then the DOJ's proposal is a little bit more promising because it avoids some of the First Amendment problems. But the sort of other problem is, well, they always say, well, you can roll your own, right? Yep. But then, of course, maybe not so much because we've seen Parler get delisted from app stores. We've seen
and Amazon pull their servers.
Yeah. We've seen MasterCard make threats against people. They made threats against Patreon back in the day that they put on their Twitter. That was good. It's like, let me just make an open statement as MasterCard. If you don't do what I want, I'm going to whack you over the head. That sounds good.
Sure.
So maybe some of the solution here is an antitrust to prevent them from, because there is an idea that sufficiently large companies can't do things that smaller companies could do because if sufficiently large companies do it, it might be sufficiently anti-competitive that it could be regulated. Mm-hmm. So, it's not like the Sherman Antitrust Act couldn't use it once over. So,
Well, one of the things we've been covering in the channel for however many videos, 50, I don't know, is Apple versus Epic, which is next month. It's going to be a hoot. And certainly, I came under fire because I basically disagree with Epic's theory of antitrust. But I also talked to my viewers and said, look, man, everybody agrees the Sherman Antitrust Act doesn't mean what it says because you can't read it and have it mean exactly what it says vis-a-vis restraint of trade. And so it's all just kind of amorphous. People say, well, why can't you tell me who's going to win the case? It's like, I can tell you, I don't think Epic's theory is right. And a given judge can decide whatever they want under Sherman. So, you kind of got to watch it and see where the wind is blowing. And that's one of the problems with American antitrust is you don't have that kind of certainty. And a lot of it depends on what the Department of Justice is doing and who the executive is. Trump's Department of Justice.
Right. I don't know who's right in the Epic Apple thing, because it comes down to like questions about like undue tying, undue bundling.
But I mean, the question is there a market, right? Like the fundamental question where I believe Epic loses is that you've got a market that was built by Apple in Apple products. The only way they win the monopolization argument is to define it as access to iOS, not sales of Fortnite, not access to selling markets of video games. Fortnite, you can play Fortnite on certain calculators, I think, at this point in time. So it's all, does Apple have the right to restrict access to Apple products? And ordinarily, historically, the answer is get out of here, Epic. But we live in an interesting age, and I don't think it's get out of here for this court case.
You're probably right in the end. You're probably right that that Apple does have the better end of the spectrum. The comparator that I sort of think about is like a heads-up unit in a BMW. If you wanted to put, stuff on an app store in a BMW head unit and put your own app on there, BMW or CarPlay, as the case may be, is not going to let that fly. And that seems somehow more tolerable. And I'm not sure why. And so since I can't explain it to myself, that's usually a bad sign.
Well, I mean, I think Epic's got a lot of good points, and that Apple's an easy company to hate. Epic has a lot of money and a feisty CEO, and that's how you get a court case like this one, which is interesting for you and I and those of us who are following these kinds of things. But, somebody asked me, when's this going to end? And I said, I don't see the loser not appealing. So, I mean, we're in it for the long haul with Apple versus Epic. And the fight is for Apple getting 30% and Epic not having to pay 30% on Fortnite, which makes billions. So you can pay lawyers a long time on this one.
That's true. The legal fees will be nothing compared to the potential gains. So,
And once that happens, once you got those $1 billion cases, it's like, this is when this occurs. Apple's fighting for its life in terms of the economics of the App Store, and Epic's fighting for a whole lot of money.
Yeah, it's an interesting problem, because if the idea is that you should be allowed to allow parallel market on the iOS device, then it's like, can Apple capture any of that or not? So many fun questions. I'm glad I'm not the
it'll be a
judge
fun
one. So let someone else figure it out and see how it goes. All right, for our next comment, it is our favorite person, Susan Wojcicki.
I love this.
Who apparently decided that she would like to give herself a free expression award. Fun times. So
I didn't know that Newsweek covered this. This is great.
Yeah, she received a free expression award from the Freedom Forum Institute, which is a video platform, and it's Google, and it's YouTube, and all the rest of it. And then she gives this wonderful interview, and I use the word interview very loosely because it's quite clear that the person giving the interview and the person giving comments back are not in the same room at the same time, because the interviewer is asking these like really generic pre-written questions. Like, that is a good question. How did you get so popular? It reminds me of The Simpsons, like an early episode with The Simpsons when Lisa has to write this pre-written question for Montgomery Burns, who is running for governor in that episode. It's like, your campaign is on a runaway train. Why are you so popular? It's like, yeah, that's basically what's going on there. So yeah, Susan gave herself a free expression award, and she said things like, we believe in free expression. We believe that all viewpoints are valuable. And also we'd like to make sure that, certain viewpoints don't crowd out other viewpoints, which seems kind of inherently impossible. I'm not even sure how that works theoretically, but okay. And other things. So not 100% sure that Susan knows how the free expression works.
Well, it's funny, right? Like I obviously am using YouTube. I'm a YouTuber. I like the ease mostly when they're not moving buttons around and getting videos up and then running on the platform. But even in the last 2+ years where I've done virtual legality, one of the reasons I started it was I had a couple of clients that were dealing with putting videos up on YouTube and dealing with some other social media outlets. And I wanted to know better what they were dealing with. And it's been eye-opening to just see how much kind of random BS you have to deal with to get videos up, to make sure they aren't struck. Earlier this year, one of the reasons that I wound up looking for other ways to keep the channel going is that I got a I don't know what you call it in YouTube, a warning strike, like the first strike, but it doesn't count, except that it counts for your warning. So the next one is one of the strikes, and it was for harassment. And if you ever watch Virtual Legality, I don't swear. I don't believe in ad hominem attacks. I have shirts that say reasonable minds can differ. I'm all about trying to have the conversation rather than just attacking each other's humanity for whatever position that you hold. That's what we like to do in that channel. So I got this strike, and I of course did a video on it because I'm a YouTuber, and it really does open your eyes, because it's like there's nothing remotely close to, in that video, which was talking about harassment guidelines, that was close to harassing anybody, that YouTube, just watching it. And I have a number of my videos that have, I don't know if you have these, the warning cards that say, the CDC says all these things about coronavirus. And
I haven't seen one of those in a while, but definitely for the election, I got a lot of those.
And it's like, I'm not even talking about, what? So, it's kind of imposing themselves. And I did a video. They had a number of quotes. 2020 and 2021 has been eye-opening for a whole lot of reasons. But they had a number of quotes that said, basically, we're going to lift up authoritative voices, and essentially press down on non-authoritative voices. And I was telling my commenters when I did a video about it, I said, this is ridiculous, because according to YouTube, I'm not authoritative on contract law or the things that I talk about. When, random talking head at Fox or MSNBC or whatever your preferred hated network is authoritative for this purpose, because it's just names in media and things like that. And so it's really interesting to now come out here in April of 2021 and have the head of YouTube give herself an award sponsored by YouTube for how free their expression is on the platform, when I have found basically a constant chilling effect as a legal term of art, in terms of trying to make sure that if I make something about YouTube, I allied some of the references in the title or the description or the tags to make sure YouTube isn't watching it that closely, because it gets depressed on the algorithm, all this crap. And it's interesting. It's interesting. I would not classify YouTube as particularly free expression oriented. But, when you can pay for the awards, God knows I've worked at a law firm or two that have sponsored a speech and award for themselves.
Oh yeah, no doubt. That's true. That's true. So we can't be too harsh on that respect. Yeah, the idea of giving yourself awards is not exactly the first time.
Although hasn't done that yet, but certainly I've been around the bend.
Well, I'll give you an award. I'll give you the Uncivil Law award for civility or something. I don't know.
I like it.
Yeah, there you go. Yeah, so it's interesting too from a legal education channel, because I cover content of all kinds of different things, and I've noticed in particular some trends in demonetization. I've noticed if I cover a family law case, and the guy wins, it doesn't go well on my channel. Unlike
the curves.
I've no problem with women winning when the result requires it, but
of course,
they seem to very much dislike it when the man actually comes on top. A number of them have come out that way. A number of my Title IX cases, when I've covered men who were falsely accused or get bad due process,
like university cases.
Yeah.
Okay.
Bad due process from the universities, bad hearings, and those don't seem to do well and get demonetized. I just did 3 stories relating to women's right to choose, because I covered Griswold, Roe, and Casey.
Oh,
and Griswold,
that's brave stuff here on YouTube.
Griswold was demonetized, Roe was demonetized. Somehow Casey was monetized. I'm not sure how that works, but okay. Maybe they don't know what Casey is yet. But
it's possible.
I just had one yesterday, it was Monday, where I had this very, very dark story dealing with this 8th grader. And it was really, really dark and painful. But, I've tried to get around the thing by changing word choices. Like I'll say, this person was convicted of an attack of a violent, prurient nature. It's like, say things like that.
No, exactly right.
Getting around this stuff. I'll say all kinds of crap to get around it. Sometimes doesn't work. The fact that I'm having to choose my words, I can't use legally precise words when I'm covering legal cases. It's a little bit irritating.
No, and that's exactly right. Like, they have this blanket rule, and of course they put out a blog post this last month that says, well, we're going to back off this rule a little bit. But they have this blanket rule that says we're going to probably demonetize you if you talk about anything controversial. It's like, we're doing news videos and analysis on stuff that is being talked about today or yesterday or a couple days ago. A lot of the times that's going to be controversial to someone. And this I think happened to everybody last year. Anytime I said the word coronavirus, everything was gone for, 2 months. And somebody said, just don't say it. I said, I'm not going to not say coronavirus. It's the biggest news item of my lifetime. I mean, the videos can say that. I don't know everybody's saying it. Why would this be demonetized? But I mean, like, that was the state of play. So you got people saying whatever they're saying, however they're describing it in various videos. It's just ridiculous.
Yeah, and some of those appeals go through and some of them don't. And of course, YouTube never gives you any reasons for anything.
It's a black box.
It's a black box, and the reasons they do give you is please consult our policies, which are written so broadly, they don't help. And then YouTube recently came up with a video. I don't know if you saw it, from their official creator channel or something. Was basically like, is it true that person follows all our policies, can never less be demonetized and kicked off our platform? And it's like, yep.
Sure.
Even if you follow our
right
policies,
in the terms.
we can kick you off, demonetize you, remove your channel because, reasons. And
reasons.
It inherently means they can't give you reasons, because if they did give you reasons, that would just be a new term and condition. And so it's like, if it were in our terms and conditions, we could tell you what it is because it's in our terms and conditions. So because it is in our terms and conditions, we can't ever tell you, because if it is, it would be in term and condition. So the whole thing is somehow Kafka-esque, self-referential in some way that is very sort of, I don't know, disturbing on some level.
Well, my favorite part about Google and Facebook and Twitch and all these terms and conditions mostly have this framing device that I don't see in any other kind of contract, which is this one reason to terminate you or otherwise cause you trouble is if you get close to the line on some rule that we have specified, right? And this is directly in the terms of service. And so, I've done videos where I say, understand what this means. This means you didn't cross the line. They have a rule. You didn't break it. They said, yeah, it's close enough. It's like, wow.
Does that inherently mean the line was somewhere else?
Yeah, no, of course it does. So the line is where they feel
close
like
enough
it.
to the line, so that means the line was really somewhere else, and there's a shadow line. It's like a double secret probation thing or something.
No, and YouTube, has the blog post, as you mentioned, that now has did Hogue or Uncivil Law tweet something we didn't like? Off goes the channel. It's like, okay.
Yeah.
I mean, people need to know this. Part of virtual legality is, let's read through some terms of service so that if you want to fight about things on the internet, bring these to the people that write these attention. Have that conversation.
And Jessica says, I forgot I'm a member. Spent the weekend watching a few of your videos. Found out you're a Clemson alumni. Always glad to have Clemson alumni. Jessica, go Tigers. Represent deep forever.
Poor Wolverines.
Yeah. Well, we're doing well. Our quarterback is going to be a first round draft pick. How's your quarterback?
And deservedly so.
Yeah,
mine is not.
Yeah, no, not so much. That's okay. Well, we have some more stories, and this is my personal favorite case of the year.
Okay,
that's going to be it. This is being argued tomorrow at the Supreme Court. It's my personal favorite case that's being argued this year. It deals with off-campus speech and pictured Brandy, who is now a senior, I think, in high school.
Okay.
So this whole story is very, very interesting. I'm going to slightly get the facts wrong, I think, because it's been a while. But I think she was an incoming freshman. She was going to be on the varsity squad for some reason. She somehow displaced a sophomore who was on the JV squad there was some sort of shenanigans, bad blood thing within the team already. And also like this, which is relevant, this person who was displaced, this sophomore, her mother is like one of the coaches or something on the team. So that was a whole thing. Anyways, our protagonist here, Brandy Levy, she was thrown off the team because of all this, or there was some problem. I forget exactly. So she went off campus and she wasn't wearing her school uniform or anything else. She took a Snapchat somewhere, not on campus, and just said, F school, F cheer, F life, F everything. And I'm like, yeah, so
teenager.
You can see the exact quote right there. F school, F softball, apologize. F school, F everything. Don't want to misquote her for her, So anyways, the school kicked her off the team, saying that they violated the cheerleading code of conduct, which, given the exact language of the conduct code, I don't think she did. which is another thing, that she was creating disruption and blah, blah, blah. So this is going to be oral argument tomorrow. I covered this at the district court. She won. I covered it at the Court of Appeals. She won. So now the school is going to the U.S. Supreme Court to figure out whether or not they can, from 4 years ago, discipline this girl because she said F school, F softball, F cheer, F everything. So good times. So I don't know if you have any thoughts about free speech on and off camp. Okay. And of course, I probably don't need to tell you what the school's argument, but I will anyway. The school's argument is, well, if we can't deal with people, what they say off campus and on these private platforms, then how are we going to deal with cyberbullying? How are we going to deal with all these things that are happening that influence the school? We have to have the ability to do this because it's disruptive to the school environment, don't you?
Well, disruptive being one of the magic words for jurisprudence, right? Like that's how they've been allowed to do the things they've been allowed to do, is disrupting the school environment and those kinds of things. So I have no doubt that they found the way to work the word disruptive into the argument. I look at that, just hearing the story, because I haven't been following this one. It's such an interesting Supreme Court case. You hear the phrase, make a federal case out of something. It's like, it's a teenager saying, screw the school. Why would you even, I don't, this is where I sound like old man shouts at cloud. In my day, I would have been taken aside, would have called my parents. We would have had a talk, and, it would have proceeded from there. That being said, evaluating it as a constitutional law case, if that were a private institution, if that were a private cheerleading club, there would be no problem. But I presume, based on this fact pattern, that the school is an organ of the state. And so, I look at that and say, you don't have a good disruption claim. You don't have a claim really about the educational environment, which is what those disruption precedents are supposed to be about. That if she were in class and jumped up and yelled that, then okay, school, you can do something about it. But if she's on Twitter at home, what exactly is that disrupting? And I would expect the line of questioning to go that direction.
Yeah. I mean, I don't think it quite is even Tinker, because Tinker, which is this all being built off of, Tinker versus Des Moines, which is the black armband case during the Vietnam War. The school talked about potential disruption, and the Supreme Court basically said you need more. You need more than just potential disruption or potential. You need evidence of actual disruption. And some of this disruption was caused by the school itself. I'd like to take note because of the whole things I mentioned with the cheer, with the team and the blah, blah, blah. So the school is upset because, people were passing this message around and there were like whispers in the hall. I think Tinker requires a little bit more than that. Yeah. So you could see this going a whole bunch of ways. You could just see them being like, go read Tinker again. Or you could go with a more bright line of, if it's off campus and it doesn't relate to any, the only way it relates to a school activity of any kind is because it mentioned cheer and softball in the text.
And from that quote, it didn't mention the school itself, did it? Was that in her profile or something?
She just said F school.
Right. I don't know a teenager that hasn't. Right.
Apparently it's bad, very, very bad. The school figured it out, which is enough for them.
Look, I would have gotten a detention back in the day, but in terms of this, I don't know. I would probably side with the student on this. I think that you have to be allowed, especially in our constitutional jurisprudence, forgetting that she's a kid versus an adult. Generally speaking, you got to be allowed to tell government bodies to go screw off. That's our God-given American right.
Yeah, and then of course Tinker itself says you don't lose your rights at the schoolhouse gates, and we weren't even that far. Which it's like, so what rights are there outside the schoolhouse gates? So
that said,
it's not exactly like in the era of Tinker that people weren't talking outside school and creating disruptions outside the school environment that impacted the school environment. It's not like there wasn't gossip and people talking amongst themselves and things being exchanged, and it was a little bit different than social media, I guess, but the idea of it's not fundamentally different in some way, it seems to me.
No, and this is where you really do get like the difference in generations. I feel for some of the younger folks because it gets so immortalized. I think you said it was a Snapchat, right? So she might have even thought it would disappear, and somebody took a photo of it or something. So I do feel for those kinds of situations because I can't recall, Senator, but I'm pretty sure I would have said something the same to or about my school.
I'll say it now. F my high school. Why not? I'll say it this many years later. You know,
my high school experience is the same as everybody else's. Good days and bad days. You know, I'm sure I said something.
I'm sure. Okay, something else that's close to my heart.
Okay.
Gun rights is a major area of my interest and focus. Personally, because I love Second Amendment stuff. So the Supreme Court has agreed to hear New York State Pistol Rifle Association versus, I believe it's going to be Bruin. It says Carlette here, but I believe the current commissioner is Bruin. So there's going to be a name change on this.
Okay.
Not that it really matters. But the long story, very, very short. New York State issues concealed carry permits and premise permits. And if they, well, let's put it slightly differently, like possession and location. So you can have it on you or you can have it at a location. If you can have it on you, it can be for a limited purpose or more unlimited, which I have exception to, but let's move past that. So it can be for something like hunting or target shooting or for basically personal defense. In order for you to get a concealed carry permit for personal defense in New York, you have to essentially show some sort of extraordinary reason about why you in particular have a threat. It can't be speculative. So basically, have you thought about being a victim of crime more? Is New York State's answer to this. So a bunch of people sued and said, you know, we think we should have the right to keep and bear arms. And we don't think that should be based on us showing some sort of extraordinary need. We think maybe the Second Amendment says there's a right to this and you can't do it based on that. So the Supreme Court is going to take that question up. They haven't announced a formal time. Presumably it's going to be early this fall. So presumably October or November, which means you're looking at a decision probably in February. So we're 10 months away from an answer. So Richard, tell us what the answer is going to be.
Well, I can't imagine with the skittishness of this Supreme Court that they didn't take it up to clarify a limit on the ability of states to restrict gun rights. But I've been wrong on the Supreme Court before, and I don't trust them as far as I can throw them. So I suspect that end of the day, you're going to get something that says you need more quantifiable metrics than I think I saw proper cause in that reference that you just put up, because otherwise it's too ambiguous. And while the Supreme Court has never quite defended Congress shall make no law, they have at least tried to limit those restrictions to something quantifiable historically. And so, you know, they passed on however many Second Amendment cases they passed on last term. And I think it's significant that they decided to take this one up because this one does sound, and I haven't followed this one either, but just as you describe it and as I saw in that article, to be a bridge farther than some states are going with their rules. If you can put some quantifiable metrics, I think a lot of the Supreme Court is going to go for it. If you say proper cause and you have to pledge fealty to some board somewhere, that's I think probably a little too far for certainly the right side of the court's appetite, but I think even the middle.
Yeah, I think that's right. I think that the argument is going to be, and the end result probably is going to be, that you're looking at a decision that essentially says that while the state can regulate the right to carry under some conditions, which we're not going to specify any further because of course
they won't.
So you know, some places, sometimes, some manners that the state may be able to regulate in ways that we're not going to tell you about. But what they can't do is they can't base it off of a showing of a specific need or some sort of, they have to make it essentially available to every law-abiding citizen.
As long as you fill out the 600 pages in New York, but
I fill out the 600 pages and pay the $600 and wait the 600 years, you know, all that stuff. But that's basically what you're looking for, which, you know, at this point is enough just because we haven't had a decision. When was McDonald? Was that 2009?
It's a while ago.
It's been like 11 or 12 years since McDonald. So it's been a little bit now. So you need a right to bear outside the home in some situation before you can start going for more. So, you know, Heller was the core right. You have a right to keep in some situation. That would be the home. So the eventual NYSRPA case presumably is going to be 5-4 or 6-3 of you have a right to carry in some situation under some circumstances as may be regulated in ways that we're not going to tell you about, and you can't deny it based arbitrarily because it's too arbitrary and capricious.
Right.
Something like that.
And look out for that 5-4, because if you got Roberts right in it, it'll be a good time.
Yeah, I'm not really convinced that Roberts is going to be on the majority side this time around. He was there obviously, and he was there in Heller and McDonald.
He'll swap to write it.
Yeah, I guess that would be interesting. I wonder. Yeah, it'd be interesting if you try to prevent that from happening by some sort of clever combination of votes. But yeah, he might be able to swap just to be able to write. That would be annoying.
I think he's done that a couple times already. He's not my favorite justice. For those of you that don't follow virtual legality, he's the worst.
I don't like Breyer. He's my least favorite.
Okay.
He drives me crazy.
I'd take virtually anybody else as Chief Justice. Either side. Don't care.
I think Kagan would make a good Chief Justice.
I agree. I tend to like Kagan and Alito.
Yeah, I'm not so sure about Alito. I think Kagan would be a little better choice. But yeah, Breyer drives me crazy because he asks these very long questions and long-winded hypotheticals that go nowhere. It's like a Grandpa Simpson telling a story about going to Shelbyville with the onion on his belt. It's just like anytime you want to get to the question would be great. And he comes up with these analogies. Sometimes I'm like, what is going on? So
that's been the fun part of the last year, right? In Google versus Oracle, you got to listen to these old guys try to figure out what was even happening. It was really amusing.
Good timing. Let's talk about Google versus Oracle, because that's a decision that's of mutual interest to us. So yeah, so Google jacked Java, Sun Microsystems, Oracle's code,
right,
relating to declarative code. And the Supreme Court had two questions before it. One, is this code copyrightable?
A foundational question.
If it is it fair use? And they decided to only answer question number 2.
Sure.
And they said it's fair use. Now, I'm not sure. I don't think I agree that it's fair use. I disagree. But of course, me concluding it's not fair use would necessarily require me to conclude it's copyrightable in the first place, which I'm not sure about. And the Supreme Court didn't bother telling me about. So what is your view on, was this fair use and all the rest of it? Because the Supreme Court didn't want to tell us.
Yeah. So, I mean, for people that aren't regularly reading Supreme Court decisions, one of the ways that the court usually handles these things is you solve the narrowest possible question. And this decision comes out and says, well, we're going to solve the narrowest possible question by going to fair use, where if you know the Copyright Act, fair use kicks in when there's copyrighted material. So generally speaking, you answer that question first. Was there copyrighted material involved here? Then you ask whether it was used in a fair basis. They say, no, that's a lot of work. We don't want to do that. We want to talk about fair use for whatever reason, which is, I think, primarily because they wanted Google to win. They thought they could write it with this fair use analysis. And they really didn't want to make what they would view as a kind of more sweeping position of this kind of code is not protectable at all. So you get the kind of now traditional U.S. Supreme Court kicking the bucket down the road, which is we're going to say a lot of really broad things about fair use, which as a guy that regularly looks at fair use and talks about it with fellow YouTubers and people that are really interested in that particular doctrine, because, hey, everybody's doing everything in fair use on Twitch and Twitter and everything else, don't you know? Because they tell you so.
Yeah, it's because they put it in the YouTube comments. They say it's fair use.
It's in the comments.
They say it's fair use, so therefore it is.
It's done. I'm using this for fair use. You're done. And it's one of those things where you look at it, and I tend to agree that Google probably should have the right to use this on a practical, realpolitik basis, because it's kind of the way software is done and that kind of thing. And so I think looking at it as whether it's copyrightable or not is a cleaner look at the case than if you read through the fair use factors. If you know the 4 fair use factors and you actually read through this court's analysis, they're slightly crazy. Like every single factor is like, what?
No, my personal favorite on the craziness, and I had a really strong comment about this, is where they talk about the commercial use versus non-commercial use, because I'm paraphrasing this, but the Supreme Court said, if paraphrasing that, that non-commercial use makes the factor tilt towards fair use, which is a fair conclusion, and then said that commercial use doesn't do the opposite. So I'm not even sure how that's possible.
Well, they skipped it. It's rhetorical, right? So if you look at those two paragraphs back to back,
I did, and I came out with, I couldn't gel them.
Yeah, what they're trying to say is, sure, non-commercial means it's more close to fair use, but commercial doesn't win the day on the other side.
Yeah,
even though there's
we know that.
Yeah, well, we do, because it's a balancing test, right? It's
Right.
Fair use is stupid in terms of, again, like so many facts and circumstances tests. Who knows what any given judge or court is going to do with it, and that's difficult for the client sitting on the other side of the desk. But you look at this and they say, okay, yeah, sure, it's a little bit commercial, and Google's made a little bit of money on that Android platform, a little. And then the dissent comes in and says, sure, they were going to license Java, and that fell through 4 times. And sure, when Google stole this code, the Java license lost 97% of its value to Amazon, and all this other stuff that I forget who wrote the dissent. Thomas, maybe?
Yeah, definitely. I thought it was very good.
No, I think it was. And I said that in my video. I kind of put them, I combined them so I could bring up each factor with the opinion versus the dissent. And I look at it and say, I end this and say, I think the dissent won all 4, or maybe 3-1. And at the same time, I say, I totally understand everybody that comes into my comments that talks about this and says Google has to win, or else we got really bad things happening in software.
I didn't really believe that.
Well, I yield the ground to the experts on that kind of stuff to some extent. But to me, it's the court wanted to say it's not copyrightable. And for whatever reason, they decided not to. And they created a whole bunch of problems. The biggest one to me on fair use is they started talking about the public interest mattering to the use rather than just what your use of it is. And I said, oh my, the can of worms with that analysis is insane. That's coming up in Apple versus Epic. They're going to quote that about all of this stuff, because it's so broad and it's so against the statutory language of what it's being asked of you for fair use that I looked at that and said, yep, that's getting quoted in every case about fair use ever again.
Yeah, no. And the other thing that sort of drove me crazy about the case was it came to transformative use, because the majority's opinion was, well, they took this code and they did something much different with it than was envisioned by Java, which is probably kind of true, and therefore it's transformative. But it raises the specter of, like, when would it not be transformative? What does the not fair use case look like? Because anytime you're taking code and you're putting it in other code, it's going to be pretty significantly different. So I'm like, okay, my problem was, among others, if this is fair use, what's not? What does the hypothetical not fair use case look like?
Yep.
And I couldn't figure it out.
The dissent asked that, right? They have a section that says, when does this not apply to this kind of stealing? And I think they're right. I think you're right, which is to say never. I mean, this is not effectively copyrightable if it's fair use by law for this purpose. Because one of the other things they say in that case is you took the code, you're using it for the same reason. It's the structure of your software, but now you're opening it up to mobile platforms, which is different. And the dissent has a great line that says, are you kidding me? Am I allowed to steal a script from my theater because the other folks already know the words? And I'm presenting it to different people in a different capacity, and I think it highlights why the fair use analysis is so weird for this particular use case, even if you think Google should win at the end of the day.
Yeah, and I also noted that I don't know if it was the majority or otherwise, but they noted that not only could Google write a lot of declarative code, they did. They wrote a lot of their own code. So there's nothing stopping them from, they could use the ideas that were built into Java, like the structure.
Can't copyright ideas.
You can't copyright ideas, so they can use the structure. They can use the, because they have this hierarchical structure like java.lang. whatever. So you want to use this kind of similar structure. You can't copyright that. You want to use the way that they do the function calls in sort of the format. You can't do that. And you just have to write your own things. And they did write their own things in large part. This is also why I didn't buy the parade of horribles of, this means that, every piece of software is going to be taken off GitHub. This means that, every program won't be able to run because they're using codes from the IBM BIOS from blah, blah, whatever and stuff. I'm not sure any of that holds, because not only do people write languages, they write them all the time.
Sure.
They write their own code. It's not. It's like yeah. I also liked in the majority opinion where they're like, well, if this went the other way, it would mean that Java would hold the key for all of time. And I'm like, that doesn't sound right.
The code they wrote.
That implies that Java is the best language and always will be the best language, because everyone will always want to use Java as declarative code, and no one will ever want to do anything different because Java is the greatest. So if we locked it up, that meant that Oracle would control the world forever. Like, I'm not sure any of that makes any sense.
Well, and I think, if you really want to break it down, it's like that oral argument for this particular case really was eye-opening. Like the justices are all over the place as to how software works and what it does and whether it is copyright. And, that one is a fun one to watch because you really do get that understanding that it's humans all the way down, and the justices are not magical because they got robes.
I like this comment from Q Squared where he says Scott has answered the fair use question in a way that seems they were answering the question being copyrightable as no, and then said, oops, it needs to be fair use and be happy. Yeah, there was definitely that impression where it felt like, it felt weird in its editing style.
It really did.
Someone else had a question about how you think it will impact fair use going forward, how it will impact the 4-factor analysis.
Well, so, there are a lot of people online that went out with, oh, this is so broad and it's going to affect so many things. The Supreme Court tried at the end of their opinion to really limit it to declarative code for this specific purpose and this specific fact pattern so that they could squash on somebody that's trying to use some of their more zany fair use elements from the opinion. That said, as I already indicated, they're going to get quoted on the public interest mattering to fair use till the cows come home, because that is essentially ephemeral argument that's open to everybody. Well, it's fair use because when I put it in my video game, it was educational about colonial America in a way that others didn't realize. And so I should be able to use all of that code or that video or those assets or whatever. If you have to actually use that argument, it opens up a lot of doors for when fair use might apply. And I think they'll try to kill that. Like, they don't mean that. The Supreme Court does this too often.
Yeah, no.
But that's the first thing that jumps out at me, which is, you can be as commercial as Google making money on Android. So billions of dollars. You can transform something by using it for the exact same reason for a different purpose, and only because a lot of people already know the thing that you stole. So that's great. If it's in the public interest, that can help you get to fair use. And end of the day, I think it'll be quoted by a lot of copyright attorneys. And I suspect for a short period of time, it'll be useful. And then eventually an appeals court or the Supreme Court will say, no, it was just for that. We just wanted Google to win.
Yeah, probably. There's no reason. That's just why it's so frustrating, because there's no reason on its own logic there's no reason on its own logic to limit it to declarative code. There's no reason on its own logic to limit it to this case. The case is broken. Rogue. It's
no, it is. It's entirely broken. That public interest declaration is.
Open
my eyes.
We'll quote this. We'll quote the spiffing Brit. The Google versus Oracle decision is a perfectly balanced decision with no exploits.
There you go. Exactly. No, and I get it's a complicated decision. It should also open people's eyes for how much the Supreme Court has difficulty with technologically based decisions. It's very bad at them. And some of that is from the age, some of that is from their experience, but it's very bad at those. It's often very bad at intellectual property. I don't know if you've ever had this experience where the justices occasionally just get mixed up on trademark and patent and copyright when they're asking questions. It's like, oh my God,
They're all the same. At least copyright and patent do have a bit of a history together. Yeah. So it's not exactly crazy to ask copyright questions in the vein of patent and vice versa, because they do have a shared history there. I mean, they are part of the same clause of the Constitution, so you got that going on for you too.
There you go.
So
it's always eye-opening when the justices ask something and you're like, ooh, I got an episode for you guys. Why don't you check it out?
Yeah, really. And for our final question, I thought we'd talk about, I think this was your video from today, but I thought we'd talk about it in light of an article from 2016. About from the Los Angeles Times about whether or not consumers are being deceived by the buy now button on Amazon or iTunes that may not be able to pay for. So this is from 2016.
All right.
I don't know if this is necessarily the first time that this issue was raised. I'm sure not. But I thought it was just interesting to say this has been circulating around. And there are these two law professors at Case Western, UC Berkeley, who
Okay.
are like, well, they like the fact that people aren't really buying these books isn't well known. And then they have this wonderful quote here: the multi-billion-dollar digital marketplace is built on a lie. Companies like Apple and Amazon entice their companies to buy now in Ocean HD, but consumers don't own anything, at least according to licensing agreements that accompany the sale. So this idea, and then they say, it's time for the FTC to step in to end the deception. So I just thought it was interesting that this idea that's currently in play is not a new idea, and I tend to think that it is deceptive because
I tend to as well.
Yeah,
Even as a corporate lawyer who looks at these things and generally likes to read the terms of service and say, look, here's what you agreed to, all these kinds of things. I have always thought that the juxtaposition of a button that says buy that leads somehow on any given website to a terms and conditions that says the content is not sold was always a bit of a, it's like, wow, as a lawyer, I can understand what you mean is you're buying a license of some kind rather than
bullshit. That's bullshit.
Well, again, as a commercial lawyer,
what is the word? I mean, let's go to like property 101. Let's go back to our first day of property law, which at least for me, my very first class in law school was a property law class. So it's like it has a special place in my heart. So my very first class in law school was a law property class. So it's like, what does it mean to buy something, Richard? What does it mean to buy a thing?
Take exclusive ownership.
Should we talk about the bundle of rights? Should we talk about the sticks in the bundle?
I think I've used the sticks in the bundle a couple of times.
Yeah.
The sticks are useful. That's good educating right there. As I started out with, I tend to think that this has legs. I also did ask the question in my video though of, the response to this is a button that says buy temporary license and buy perpetual license or buy indefinite license or whatever. And, are the people... I don't
even know what that means. I don't even know what it means to buy a license.
Well, you do buy a license.
I could buy, okay. It's confusing. It hurts my brain.
I don't disagree. I am not sitting here disagreeing with you that what happens when you spend $20 on Vudu and can now watch Wonder Woman as many times as you like, that is not something that is incredibly well handled in the current state of the law. Digital in general is not something that the law is super great at.
No, it's not. And I remember a fair use case. I think it was Ninth Circuit Court of Appeals from a couple of years back where they dealt with first sale doctrine in digital.
Yeah. And France is dealing with that right now.
They basically decided it wasn't a thing.
Yep. No first sale doctrine on digital here in America right now, which, I always say to people that get upset about these kinds of things that I'm very much in favor of reading the laws as they are and advocating for them to be changed when appropriate. And I think you have an argument for some kind of first sale protection for digital goods. Certainly the EU and France in particular is currently got a decision on the books that says there's first sale for digital goods that's being worked through their court system. And I can't pretend to know what that process looks like. But I do think that is something that is deceptive to the consumer, that the terms and conditions, which are inevitably, let's say 25 pages being conservative, are not going to be read by anybody. That the license not sold, and here are the restrictions, and here and there's always a provision that says, hey, by the way, if we lose access to it, or if we decide we don't like you, zip, they're gone. That's not something that a lot of people read. And that, honestly, if you had to write in that button perpetual license, let's pretend that we all understood what it meant. If you had to write that on the button, I think the value of that would be lowered. That the reason it says buy is the connection in people's brains. And if you had to say license, then it's $18 and not $20 for some amount of people. And so they are, in fact, unjustly enriching themselves on a deceptive act faced at the consumer. I tend to agree with the thesis there.
Yeah, and what's interesting is I should be able to beat all these licenses with 3 words. I should make them all vanish instantly with 3 words. You ready for this?
Sure.
Restraint against alienation. There is an idea well baked in law and personal property, which if we're buying something that's a good, presumably it is, that you can't, as a condition of the sale, restrain alienation, which is your ability to further sell, further get rid of. When you alienate something, you separate it from yourself.
Sure.
So my ability to alienate a good is my ability to sell it to you, my ability to destroy, whatever. So the very idea of you're buying, and it's subject to terms and conditions and a license, It's like I should be able to just kill that all instantly. It's like, no, you can't do that. You just fundamentally can't do that. You can't have a license. You can't have terms and conditions because you're fundamentally trying to put a restraint against alienation. And that's a no-no that goes so far deep into the common law, as you well know.
Sure,
but, should just not be
but you're saying that you're taking that from the ownership and the purchase side of things.
Yes.
We can certainly allow people to license things. We do it all the time. We do it either on a commercial basis or a professional basis. We have licenses for everything. So the question is, when we're talking about what should be allowed under the law, maybe buy is the wrong word, maybe purchase is the wrong word, but should an enterprise be able to license something to you on a restricted basis if you and I had a meeting of the minds for what you were buying? And in general, I'm going to be in favor of allowing those two parties to decide on what it is and what the value of it is on the rules that are set forth. The problem I have with it is that I agree that the average consumer, the reasonable customer, doesn't have any idea what $20 gets you.
Yeah, change all the buy buttons to rent. Let's see how well that goes over.
Yeah, long-term rental.
Very long-term rental, very long-term.
What's the truth?
Yeah, I know.
It's closer than buy.
Yeah, it is a lot closer than buy, which is also what they try to do with the Academy Awards, which is a kind of a random factoid. But they try to say that like when they give the Academy Award to the artist or whatever, they're not actually like giving it to you. It's all licensed, so you can't resell it. And it's
really? They try to do that?
Yeah. There's a whole thing in that. You could look at that too. It's like, so I'm not sure all that's legal, but I don't know how you want to fight.
Well, that's big companies for you, right? One of the things I first brought up on the channel was, if you're a sports fan and you ever watch the NFL say all accounts of this game are prohibited, that's bluster. You can't actually stop somebody from saying the Giants won today.
That's a good thing. All accounts of this game are prohibited by law. I'm pretty sure they're not.
No, also, they're not. NFL.
Also, why is the NFL a non-for-profit organization again? I'm confused.
Because they can be, and it makes them money.
Yeah, they're like 1201. They're like B6 or something. They're their own special carve out for some reason.
It's like the NCAA cases with like the two different weight rooms from the.
Oh, that's gonna be interesting. The two different weight rooms, and I was also thinking about the paying of the NCAA athletes, which is a decision we're expecting.
The NIL stuff is fascinating. Love that. I think it's really, really interesting.
I'm not sure how I feel about that. I feel like I'm opposed to paying the athletes in principle because I feel like it somehow pollutes the educational mission. But maybe we're already there. And maybe it's already too late.
Yeah. I mean, I think as a sports fan, from that perspective, I do think that there's a very real chance that it will fundamentally change the DNA of the sports in college. But I think it's justified for them to go get a little money for what they're doing.
Their rights after they graduate college, I'm much more amenable to. So their ability to have rights to their stuff after they graduate college seems fine. But I wouldn't allow any kind of negotiation of that in advance because, the sort of the way I think about it is that, once upon a time there was a university and they were only universities. And then the students wanted to do things other than go to school. And so they created clubs, and sometimes the clubs competed against each other and sometimes other schools competed against each other. And fast forward, and now we have, the NCAA and Tier 1 football and all the rest of it. But it's like, there's some sort of fundamental educational mission here that's I'm concerned about. And I feel like if we're paying players directly, it's not corrupting the educational enterprise. And maybe it's already too late because they're bringing in so much money that the corruption has long since occurred. And maybe it's all just some sort of nascent dream of mine that I can somehow keep the last vestige.
Hey, I don't blame you for wanting reality to be different, but I do look at it from the other side, which is, okay, so there's $1 billion. How should that be divvied up?
Yeah.
I get you. I do.
Scholarships?
Well, they get the scholarships, and now they get, essentially a day stipend, which is pretty significant. But you still have, my coach, Jim Harbaugh, making millions of dollars that he doesn't earn. And, should there be some more rights in the players? On the opposite side of the spectrum, I'm also, I look at it and say, well, if you agree to play for a school for a scholarship value for 4 years or what have you, then that was your right to contract out. But the NCAA is a cartel and they're terribly run, and I don't hate to see them burn.
They are a cartel. That much cannot be denied. And we are anti-cartel.
The NCAA is one of my least favorite organizations.
I liked it when they used to call trust cartels. I think it was bad. I think it was badass. I think we should go back to calling them cartels.
Yeah, I think you might get that depending on what various senators wind up writing in their new antitrust laws.
If they ever manage to pass one.
They won't pass it, but they'll write some mean stuff.
Yeah, I don't know. It's like, I just, we believe in we believe in fair trade, fair business, and we don't want to we don't want market dominating forces to unduly curtail the market. As
Yes.
true as now as it was when Teddy Roosevelt was busting up the trusts. And the problem with, by one measure, we should make sure that we're not too secure in the idea that what is true now will be true forever, because there was a time before Facebook when there is a MySpace, and Facebook itself these days seems to be on the way out in favor of new social media. So it doesn't seem like their power is going to be necessarily secure in the long term. Even, companies that are in the, top 100, Fortune 100, Fortune 500 companies. I don't know how many Fortune 500 companies that existed 100 years ago are still there. Probably not many.
Sure.
So companies that are huge. There was a time ExxonMobil was the hugest company in the U.S., and I don't think they're even in the top 10 anymore.
No.
So different things change, but we need to make sure that there's always the opportunity for things to change, and that's imperative.
I don't disagree with that.
Okie doke. So what else should we talk about? Because those are all the pre-planned stories I had for us to discuss.
I don't know. We got into a talk about NCAA regulations. I always find that to be entertaining. But no, what do I got? See, all my stuff is video games. So you're doing politics and real world stuff over here. The premise of virtual legality is, let's see if we can talk about serious legal questions in fundamentally unserious stadia. So it's interesting to kind of get on your show and talk about some of the stuff that's a little bit more specific.
Why don't you do a video on what Cloud from Final Fantasy VII can be charged with as a terrorist? That'd be good.
Well, so this is here's your spoilers. Not even my people know this. One of the things that I've been scripting out and potentially, nobody get excited on my end, want to bring to bear is a show that would be essentially funny satirical analysis of legal issues facing video games and video game characters. Exactly what will Link be charged with for breaking all those pots in that lovely barn, and that kind of thing. And for the record, Cloud, Cloud's an enemy of the state. He's treasonous. So I mean, I'm sure he could have a lot of laws violated. Not that I know exactly what Shinra.
No, that's the fun time that you gotta. Yeah, that's the fun time you get to go into the depths of the U.S. code and you get to have fun.
Yeah, no, exactly. It's like you have to get that analysis. No, it was actually one where somebody had asked me in my channel, because I had said something flippantly, as you could probably tell just being on your channel that I can be fairly flippant on these things. That I had said something along the lines of Tony Stark breaches fiduciary duty to his shareholders in the original Iron Man when he changed the business plan unilaterally as CEO away from their most profitable sector. And so somebody was asking me about this. I was like, well, so here's how boards work, and here's how these duties work. I said, that could be a fun show.
So the Iron Man suit, maybe, is it because Tony says the Iron Man suit belongs to me, like when he's testifying to Congress in that one scene? Maybe that's not true because it's company asset. It's
perfect, right? No, yeah, it's a company asset.
So he's unlawfully appropriate company assets. So that's embezzlement.
It's embezzlement. Sure, there could be federal fraud issues, and certainly his connection with the military and Rhodey and the contracts that he has between the company and the government could be an issue.
All those disclosure filings.
Filings, but also the intellectual property.
Reports.
The intellectual property of the suit, right? Like what was used in terms of the fungible assets of the company to create the suit in and of itself. Does the U.S. government actually own the Iron Man suit? Hey, this is fun stuff.
And the fact that he's using it in public, I'm assuming no one got a patent, so he's squandered his patent rights.
Oh, there you go. Well, and then you got the guy, what's his name from Iron Man 2 that's trying to replicate him and killing people everywhere. So that kind of stuff is fun. I like to analyze the light stuff that people are already looking at, because that's kind of the way I view the world, which is, wow, this news that just came out, that's interesting. I wonder how they got the rights to do this. What did that contract look like? How did those things move? And then sometimes that becomes a video. Sometimes that's just me annoying my wife, who's put up with it for a long time. But that's what I like to do. And when virtual legality is working, you get that nugget of wisdom or thinking like a lawyer, depending on how you want to frame it. That is, yeah, the world, all of the relationships function on contracts and legal restrictions and obligations and rights. And isn't that interesting to think about? Now, I'm a little crazy. I think it's more interesting than probably everybody else, but that's what I like to talk about. So yeah, when I get a breath that I'm not just running a law firm and doing 7 videos a week or whatever the heck I'm doing now.
You were a machine. I thought I was a machine. You're a machine.
Well, it's, it is fun. I have found it fun to do this. I really do enjoy those conversations.
Oh, I love this too.
And
my full-time gig, I'd give it my day job. Just do this forever. It'd be great.
Yeah. Well, and I love corporate law and I love my clients and whatnot. But this particular aspect of things is super interesting. And one of the very first things that I did with Virtual Legality, and if you watch kind of my output, you'll see is trying to figure out how I could get the pipeline short enough that I could work it into a law firm day, right? Mm-hmm. Because clients don't care what else you're doing. They need whatever they need when they need it. And so it was a matter of and I usually describe it as how quickly can I get this from farm to table, and put those videos out and have these conversations and have something mildly looking like a professional thumbnail and get this out to talk about, because that's the only way I was ever going to be able to pull it off.
So what does your behind the scenes process look like? When do you record? How do you record?
Yeah.
What is your editing process? Give us the behind the scenes.
So I'm fitting it around whatever I'm doing that day, right? So I've got my usual notepad for the last 20 years of doing legal things. And here, I got to do this operating agreement and these filings and whatever else it is. And then I'm working around what my calls are and figuring out where the window is likely to be. Once I figure out where the window is likely to be, I'm generally thinking about what the topic is going to be. And thankfully, and I don't know if this has been the case for you as well, is, as I've gotten a little bit bigger, I've got people throwing things at me a lot. And that's, maybe half of them are like, no, I'd never cover that on the channel. Whether it's just really, really political and you want me to say something about something that I don't want to talk about on the channel, or it's not something that's going to be economical. Like if I have to do 12 hours of research for something, it's not going to be something that's necessarily going to work for the channel. But I get those ideas and I go through and I find the sources that I want to use. I get, I think I've got all the Copyright Act, certainly the early stuff on speed dial now. And that goes in there. And then I go through and I highlight. If you haven't watched Virtual Legality, one of the things I like to do is I basically show off my law school process, which is different colored highlights, highlighting provisions and sections of things so that you can read it a little better. Yeah. So I go through and I do that, and then I make sure that they're all in order and the transitions are good. And then it's extemporaneous. I found early on, I scripted a couple of them, and it doesn't have the kind of spontaneity that I wanted, that kind of conversational style. So what I do is I set up the order of things I'm going to say. I think about what the transitions are likely to be, and then I tape it. And if I'm doing it great, and this is, a 50-50 proposition. If I'm doing it great, it's taped in OBS and it is done in that fashion. I use both buttons to do intro and outro. I do all of my stuff. And then if I did it perfectly without coughing or saying something really stupid, it's set and it goes straight to YouTube. And so there isn't an edit. And if you're doing it that way, that farm to table process is, super short. A significant amount of time I have to edit out a cough. I have to move something around. I didn't have my sheets right. So I have to essentially do edits where I'm moving pages around and things like that. And that adds an hour because I use crappy editing software and I'm not an editor. Yeah. But no, if everything's going right, it's essentially OBS on a custom window that I had designed with a designed intro and a designed outro with active buttons, almost like I'm streaming on Twitch. And then a recording that can just go straight up onto YouTube. And that's why you can see that kind of it cranking when I'm flying on those kinds of things. But it's still, the average is probably 3 hours. It's not nothing.
Yeah, that's a fair amount of time. I've been usually recording on Sundays in a group, so I usually try to record somewhere between like 4 and 8 stories on a Sunday, depending on my energy level. And then I usually try to cut them up and release them on a daily basis. And right now I've got like 15 or something in the queue, which is nice. So
15 done?
Yeah, 15
ready
done.
to go? Oh, that's good.
Edited ready to go. So that's like, we can pick which story we're going to release today. So it's just looking at the list and like, what looks good today?
Oh, that's nice.
Position to be in.
Oh, see, I'm envious of that. I wake up and go, what the heck am I going to talk about? It's good. It's got to keep you up.
I look at just a lot of legal websites, and I just basically look at
Yeah,
anything that's interesting. Like, I look at How Appealing, Volek. Um, what else do I look at? Above the Law, uh,
sure,
Google
sure.
News for various legal things, Supreme Court website. Just look at things. I'm basically like, oh, that looks interesting. That looks interesting. Put it in a long list, and then I
Exactly.
pull them up, and I do a story on it. And yeah, I never script anything, which I think is obvious to anyone who watches my stuff. But I'll just read something and I'll react to it. I'm like, well, this is a whole pile of stupid, or whatever is my feeling.
And I think that's definitely a style that works for me. And the nicest compliment I can get is I do have people come in and be like, well, how long did you take to write that script? It's like, all right, we're rocking on that one. Those transitions are good if it sounds like I scripted that. But I'm also a talker, right? Lawyers are talkers.
So they said, yeah, that's what helps them to make this work, right?
Yeah, absolutely.
So I guess the next logical question is: are you going to join my milieu that I'm trying to create of
So what is that?
all the YouTube lawyers
Oh,
in my circle, where we can do a quasi regular thing? I'm trying to, get all the lawyers, together, because I talked to Nate Brody, talked to Legal Bites, talked to
oh yeah, I worked with legal
Viva,
Bites. Yeah,
talked
she's
to
nice.
Leonard French.
Sure.
And it's like just trying to get all the lawyers together so we can all. I want to do LawCon.
Okay.
I want to have panels. I want to
Okay.
have groupies. I want to
Sure.
have cosplay. I think
All
it'd be great.
Well, keep me on
So
the newsletter.
yeah,
I'll entertain that. Sure.
yeah. And so you can help me figure out how to accomplish all those objectives.
No, it sounds like fun. I do. I think that would be fun. And you got just from that list. If you got some of those people on there, it would be. I like the breadth. I like the different approaches that different people.
Yeah, it's
take in
interesting
this
just to
space.
see how the natural design is, because I didn't really sit down to say what is my format going to be. I just kind of started doing what I was doing.
Yep.
And it's interesting to see how different people do different things, and
Yeah.
just how what I do reminds me a lot of law school, but I liked it the first time.
I love
So
law school. I mean, that's
yeah.
the trick. People ask me, should I go to law school? It's like, well, I don't know if everybody loved it as much as I did, but that was fun.
Oh yeah, Dogbert says, oh yeah, we got to at some point. I don't even know how we're going to do this, but we definitely got to get some moot court or mock trial going on. We definitely got to get the lawyers involved, and we got to simulate some cases.
Okay.
That would be great, and we can get other lawyers to judge them and stuff like that.
We need some litigators on that, man.
Oh well, this is how we develop our skills. This is how we develop our skills. I get to go back into my moot court days, and I get to channel.
I was going to say I haven't been in a courtroom since moot court.
Well, that's fine. I was good the first time. I can channel all that litigation energy. Game on, man. So,
Sounds good.
Yeah. So hopefully we can do this on some sort of regular basis. I'd love to be on your channel. You are welcome.
Oh sure.
Mine, of course.
Yeah, I'm not good at guests as much yet. I'm trying to get more into that in terms of timing and scheduling and everything else. But absolutely.
Nick Ricada. I did forget Nick Ricada. I'm so sorry. There's so many lawyers that we gained together. I'm still trying to. We're trying to get Attorney Tom on board. Okay. I think I'm going to get him next. Is my next goal. So just trying to increase the list here, and then we can figure out how we're going to. Create. I sort of think that the academy is places anyone wants to go to learn. So it's like, well, as far as I'm concerned, I hire myself a professor because I can. I'm now a professor of law, so yay. So
hey, that's what we're doing.
And do stuff. That's right. So yeah,
that is what we're doing. If we're doing it right, then that's we're hopefully informing and entertaining while we do it.
All right. Well, in that case, I will wish my guest a good night. I want to thank Richard Hogue for being here. He is at Hogue Law. His name is in the title of the video. It's clickable. His name's on screen. I know it's you have to go into YouTube and create it. It's a pain in the ass, but I do it because I want people to know who you are.
Well,
so you can click right on his name in the title of the video and get right to his channel. How many videos do you even have on your channel? It's a lot.
So we're really close to 450 episodes of Virtual Legality, and then I also do, my lighter stuff. I do impressions of WandaVision and movies and video games as well.
In that case, I'm kicking your ass. I think I'm a 600 plus.
See, there you go.
No, anyways, you check out his stuff. He has a nice, soothing voice. He's a kind guy. He doesn't appear on camera as much because he doesn't love you, though.
I
But,
don't.
you know,
Yeah, I mean that's the thing. You come over to Virtual Legality, you will find that I'm not visible on screen. This is just for you.
That's right. Please go over to his channel. Please subscribe. I think you really like his stuff. He's an awesome commentator and a wonderful lawyer. I've been on Civil Law. As always, I appreciate that you're here. Remember to like the video on your way out. Hope all's well. Peace and good night.